The participation paradox: physical presence, psychological shutdown, and the myth of meaningful engagement in family court proceedings. This podcast is a legally grounded analysis examining participation impairment, trauma-informed justice, Article 6, PD 3AA, procedural fairness, psychological shutdown, and the institutional distinction between physical attendance and meaningful participation within family court proceedings. The participation paradox under Article 6 and Article 6 writes, the PD 3AA, trauma-informed justice, are not merely concepts within the legal framework. They are a policy. This is actually a policy analysis examining the participation impairment, psychological shutdown through Article 6 rights and PD 3AA, trauma-informed justice, and safeguarding failures within family court. So what is participation impairment? What does PD 3AA and Article 6 rights actually say about trauma-informed justice, the psychological shutdown, equality of arms, procedural fairness, Domestic Abuse Act 2021, Equal Treatment Bench Book, Family Court Reform, and Human Rights Act 1998 of participation integrity, and where safe chain and the unmasking justice align or intercept or bring solutions into the whole ecosystem of the justice structure. So this episode will examine one of those institutionally important yet operational misunderstood issues within the family court system. The distinction between physical attendance and meaningful participation are two distinct issues that are present in a court that does not automatically grant or recognize the cognitive participation, emotional participation, psychological safety for participation, and yet many procedural systems continue functioning as though physical presence alone satisfies the fairness obligation under the above statutes, or Article 6 rather, and PD 3AA, the trauma-informed justice. Participation impairment is a real psychological shutdown. It is a procedural requirement for fairness and the operational consequences of the systems that continue confusing attendance with engagement. You can be present and not be participating, which means your Article 6 and meaningful participation are not invoked under Human Rights Act 1998. So now let's dive in. Article 6 ECHR guarantees fair hearing rights, equality of arms, and meaningful participation, which means you have to challenge or you need to be able to challenge. But the constitutional issue is not merely whether a person entered the courtroom. The issue is whether they possessed realistic, functional capacity to participate fairly and effectively under conditions of cumulative trauma and procedural pressure. Meaningful participation requires cognitive processing, emotional regulation, procedural understanding, communication capacity, and psychological stability sufficient to engage meaningful within the court proceedings themselves, not one hearing, throughout the whole court process. So trauma and psychological shutdown. Trauma frequently affects memory, concentration, speech, cognition, information processing, executive functioning, and the emotional regulation. The Equal Treatment Bench Book and Practice Direction 3AA both recognize vulnerability and participation impairment explicitly. Yet, systems continue depending heavily upon composure, chronology, procedural fluency, rapid recall, and sustained cognitive endurance under stress. This creates the participation paradox, where the individual most likely to require safeguarding may simultaneously be those least capable of performing, participating in the systems that reward being collective, calm, and put together. The misinterpretation of trauma, the psychological shutdown, may present itself as silence, confusion, delayed responses, emotional numbness, fragmented recall, withdrawal, or cognitive overwhelm within adversarial environments. These trauma responses are frequently misunderstood as disengagement, excessive, unreliable, or procedural non-compliant. At the same time, a high control personality may present themselves as calm, coherent, confident, and procedurally effective, and most importantly, they have representation. So the danger is that systems may begin evaluating procedural performance rather than contextual reality within family court proceedings. PD3AA and the operational implementation of PD3AA requires the courts to consider vulnerability, participation impairment, and participation directions. However, many safeguarding frameworks remain procedurally reactive and not accommodate before the hearing begins. This issue is not whether vulnerability is recognized formally. The issue is whether procedural systems are structurally capable of operating safely under trauma realities. Because where procedural facing adversarial pressure and disclosure complexities and litigation exhaustion already exists, psychological shutdown may become operationally inevitable within the victim of domestic abuse and coercive control. Equality of arms and trauma. Equality of arms requires more than equal access to procedure. It requires realistic functional capacity to engage, process, challenge, and participate meaningfully. Where one party possesses financial resources, procedural confidence, legal representation, and emotional regulation, while the opposing party experiences trauma, exhaustion, nervous system dysregulation, or cognitive overload, the imbalance becomes neurological as well as procedural. So the constitutional question where these disparities occur, the question or the issue is no longer simply whether vulnerable individuals are allowed into proceedings. The issue is whether systems remain capable of distinguishing trauma impairment from procedural non-compliance. Because where trauma responses are operationally misunderstood, systems are at high risk of reproducing evidential distortion, safeguarding failures, and procedural inequality through the process itself. SafeChain argues that safeguarding must evolve towards participation integrity. This requires trauma-informed procedure, contextual safeguarding, operational continuity, vulnerability-informed evidential assessments, and systems capable of recognizing cumulative trauma realities accurately. Because safeguarding cannot remain meaningful where administrative or psychological shutdown continues and administrative function is more important than realizing what is actually happening procedurally, because then that's an operational penalized effect during court proceedings. The future of trauma-informed justice cannot depend solely upon procedural attendance, formal participation directions, or symbolic recognition of vulnerability. It requires systems capable of understanding how trauma operates, how shutdown manifests, and how procedural environments may themselves reproduce the harm it's supposed to protect. Because physical presence is not the same as meaningful participation. And where systems confuse the two, justice itself becomes structurally distorted. This is the participation paradox. And this is Silence Screams Loud Strength. Unmasking Justice. If you've been listening to this episode and you want to dive deep into the SafeChain frameworks or understand how SafeChain works, please get in touch with us. The link is in this episode below. This is exceptional constitutional analysis frameworks and operate in reality of how people exist in current forms. SafeChain exists because safeguarding cannot remain symbolic. Safeguarding must continue and must become operational, measurable, continuous, trauma-informed, legally coherent, and capable of protecting people across the systems that affect their lives. To bring safe chain training, licensing and certification, or the seal of integrity into your website, into your organization, visit our website and look at our intelligence hub that has outstanding materials. So stop treating safeguarding as an afterthought. Build systems that recognize harm before collapse becomes inevitable. I'm Samantha, your host, and thank you for listening. I will see you at the Masquerade Gala.